So, friends, it's a pleasure to be with the KLE group of people with whom I have had a very, very long association for probably 20 years, since around 2005 or something like that. So today, I would like to look at the privacy and data protection issues arising out of new technology. I understand that you are focusing on new technology of the type Metaverse, blockchain, maybe others. Right now, for the last couple of years, I have been working very uh, much in the area of privacy and data protection, which is an extension of my earlier work on cyber laws. And we have even started this FDPPI, Foundational Data Protection Professionals in India, as the apex organization today in terms of privacy in India. Now, in that context, I would like to discuss about the impact of this new technology on the concept of privacy and data protection. I will very briefly touch on the evolution of the concept of privacy, which all of you as legal professionals are fully aware of, and then go into what I look at as the challenge of new technologies, then the emerging data protection law in India. To some extent, if time permits, I will go into a little more depth. Otherwise, I will just make some mention about the emerging data protection law. Then we will look at what are the limitations of the current laws, and therefore what do we require as we go forward. So first of all, in India, we are aware that the discussions on privacy have been going on for quite a long time. And today, when we are discussing of the emerging law, we are actually looking at the new draft of the bill, which is called Digital Personal Data Bill 2022, DPDPB 2022, which is in draft form now, and we hope it will get passed in the next month. Now, if you go a little earlier, we all started discussing privacy from the concept of physical privacy. Even the old MP Sharma case actually spoke about the right of physical, you can say, ability to be, say, having some kind of segregation for a particular person, particularly in terms of search and seizure of law enforcement people. That was basically the original thought of privacy. I have to have some private, say, space where there is no intrusion. This was the concept of physical privacy, which was the one which was discussed under MP Sharma, when the court said that this is a good right to have, but it is still not a fundamental right under our constitution. Therefore, we have to make way for the law enforcement to have some kind of, say, power to intrude on this physical privacy. Same thing continued when Karak Singh case was discussed. It was also related to physical privacy. Then we gradually moved on to a different concept of privacy called the mental privacy, which perhaps came into prominence in the Rajgopalan case, where right to privacy was considered as a right to be left alone. So when you say a person has to feel that he is left alone, it has to be not in the physical world, but actually he should feel that. That is why it is called mental privacy. And the court said this is something which we should consider it as implicit in Article 21. That is much before the Puttaswamy judgment, this concept had come. So that was what we later on tried to identify, and now I would like to call that as a kind of mental privacy. But then when Puttaswamy judgment came, the emphasis was on the emerging digital era. The court felt that in the emerging situation where in the environment, personal information gets dissipated into electronic form, and because it is in electronic form, it is easy to replicate and it moves at the speed of the light, etc., the protection of right to privacy should focus on protection in the digital era. Now we are talking of the digital India, digitization of the country. In fact, India is in the forefront of digitization for the whole world. In fact, many of the advancements we have seen in the financial world in terms of digitization, we are ahead of even USA and many EU countries. They are still in the primitive age. We have already gone several steps ahead. Now, in that scenario, the court redefined the right to privacy, including the digital life. That is a very important development which we could have, we could see, because the court did not define what is the right to privacy, but went on expanding the scope of the right to privacy, and we came into what is recognized as information privacy. But when we talk of information privacy, basically we are talking of a right of a person to exercise his choice about how his personal information can be collected by another person, how it can be used, disclosed, etc. So what was called right to privacy as a right to be left alone was transformed into a right to protect the expressed choice of an individual about how his personal data has to be handled by a collector of that data. Now, that collector of the data is the person who wants to take your personal information, process it, and make some money out of it, or the government which wants to collect it for some of its governance work. We call them as a data controller in certain legal situations. In India, we call them as a data fiduciary. That is an organization which collects the personal data of an individual, is required to protect it in a particular manner, which in turn should protect the right to privacy of an individual, which he feels is the right to be left alone. So we are today in a scenario where right to privacy is being protected as a data protection aspect, and that is what is the privacy which we consider today. But as we go forward, the concept of this mental privacy will have to be further refined to include something called neuro privacy. In fact, this is what I am now working on, because in the whole world, there is only one country in which neuro privacy has been taken into the legislative area. And in India, we want to be perhaps the second country in the world. So this neuro privacy, I will try to explain a little later, is the future of privacy. So we may say that we have moved from the concept of physical privacy or spatial privacy, where our concern was only to ensure that nobody comes within a certain physical parameter, maybe the police, at least in the night, so that we can call our home is our castle and so on, to the mental privacy, which is right to be left alone, so that my information should not be published without my permission in newspapers and others. That was what the Rajgopalan case highlighted. Then we moved into the information privacy, where personal data was to be protected in the sense that it should not be disclosed except as per the wishes of the data subject. That was information privacy. And then, of course, in the coming days, we are getting into neuro privacy. And in the context of this technology, new technology, perhaps that is very much relevant. But in our discussion of the new technology, apart from the metaverse and blockchain, even before that, we need to look at the technological development, which we can recognize as the development of artificial intelligence, which is one of the biggest challenges, not only for privacy, but for many other issues. Because there is what we call as automated decision-making, whereby a data controller or a data fiduciary allocates a software, and the software decides for the humans and without any intervention of the human being, the software puts out an output which contains a decision based on the input data. So that is what we call as artificial intelligence, when the software decides on its own without a human intervention, and that will create its own issues. Metaverse is important because it will create an immersive experience with a 3D avatar representation of an individual in a virtual space, and that introduces certain issues. Now, as far as blockchain and smart contracts are concerned, in terms of privacy, if you want to look, blockchain, of course, as you know, is a kind of distributed ledger to be maintained, which means that it is a ledger of transactions. It's a recording of the transactions. But when we come to smart contracts, the contracts which recognize certain events in the cyber space automatically generates a certain kind of decision again, and that is where smart contract becomes an add-on to the automated processing, and what you may call as a blockchain actually may be a series of instructions where multiple people are involved and decisions are already input into the code, so that on the conclusion of an event, certain things automatically happen. So that smart contracts also is a kind of automated decision making. We will look at whether they introduce some kind of challenge. But before we look into the challenges which is technology issues present, we need to be clear on certain concepts. Without understanding these concepts, it is always difficult to understand the perspective of a technology person from the perspective of a legal person. For example, if you think of data, data is nothing but a sequence of binaries, which is zeros and ones, nothing more than that. As far as the computer is concerned or technology is concerned, it only looks at zeros and ones and interprets it because it is trying to interpret it in a particular manner by a appropriate application, which may be a hardware application, then there may be a software application, then there may be an operating system. So all these things combined, appropriate hardware, software, and other things, convert this binary information into some form in which a human can experience this data. A human doesn't want to experience this data as 0 and 1. He has to see a data as text, or he has to hear the audio, or in future, we may have interfaces which may be able to provide the touch and feel, or even the smell and taste. So all these human experiences are generated out of zeros and ones. So what is called data by the technology people is looked at as human experiences as far as a privacy person is concerned. Now, therefore, which data is personal, which data is non-personal, where does the Puttaswamy judgment come in for protection? This concept of personal and non-personal data depends on the basis of the intermediary device which interprets the data. For example, a data can be either personal or non-personal, and a data, even when you talk of personal data or non-personal, a data, if it is organized in a particular manner and you use an ASCII reader, it may read it out as a text. If you use a numeric reader, the same data may be read as a number. Now, which is correct? Is this data 0, 1 something, is it a number representing this, or is it something called DATA? That is an interpretation which technology people put up for humans to interpret. So similarly, this particular sequence of data may translate into NAAVI, or it may translate into a number. This may translate into PDPA or this. Now, What is PDPA? Somebody like me may say it is the abbreviation of Personal Data Protection Act. It is a non-personal data. So this data becomes non-personal data because if you input this data into an ASCII reader, it converts into PDPA. We feel that there is no personal name called PDPA, therefore it is a non-personal data. On the same breath, if this data is put into an ASCII reader and it converts into NAAVI, somebody will say Naavi is a person who is an individual, therefore this becomes a personal data. Now, how does this become a personal data? This becomes a non-personal data. It is because the human who is looking at it reads this text as a name of a person, this text as a name of an act. If both of them had looked at it only as a numerical, then it would have become a non-personal data only. Now, is this a non-personal data number? Normally it should be so. But if this happens to be a bank account number or an Aadhaar number of somebody, then even that numeric can become a personal data. So therefore, there is so much of difficulty in defining what is personal data, what is non-personal data, because data is in binary form fundamentally, and all these meanings we are implicating on this data on our own whims and fancies. That is why I have a theory of data in which one of the hypotheses I use is data is in the beholder's eyes. Data does not reside in the hard disk. Data does not reside in the CD. Data resides in our mind. And this, what happens in our mind, depends upon how you convert the binary into some kind of human experience. Now, this clarity has to come into our legislation. And in fact, in this theory of data, I also extend it to two other hypotheses. One is to say that data is dynamic. It is not static. It keeps on changing and it goes through a life cycle, which is a reversible life cycle. A raw data becomes personal data becomes anonymized data, in which case it becomes a non-personal data. Then if it is re-identified, it becomes personal data again. Therefore, data goes through a life cycle from raw data to different avatars of data. And finally, when we say data is deleted, the data gets transformed back into raw data. It is like the human life going from birth to death. Data also goes through that. And in some cases of data, it can be reversed. And this also gives rise to the challenges in terms of who is the owner of a particular data at a particular point of time. Normally in our data protection, we have an issue that because we say the right to privacy is a right of choice of a particular person about how his personal data has to be handled, I hand over certain personal data to a data controller, but subsequently the data controller uses his own intelligence, his own resources, and creates some value added additional data associated with this data which I have handed over. So data which has been handed over by the data subject gets augmented with the data which the data controller or the data fiduciary finds out on his own. Now, in this process, data may acquire value or sometimes it may shed value. So whatever is the positive or negative accretion of value in terms of monetary value, somebody has to be the owner. Now, can we say that all additional value created out of data belongs to the data subject? This is one of the views which perhaps people in the GDPR area will think that if a profile is created about an individual and later on if he wants this personal data to be ported back to him, we have to port back not only the data which the person has himself given to the data controller, but also the additional information which you have built out of this. It is like in the real estate transactions, you lease out a particular land and subsequently somebody constructs a building out of it. And at the end of the lease period, the contract may be either to return it along with the construction or after demolishing the construction. Likewise, in data also, when it acquires value, there is a question about who should have the right. Now, all our personal data handling in terms of privacy needs to take into account these issues, and that is why we need to have a particular view. So therefore, when technology looks at data, it looks at data which the data principal hands over, and sometimes which the technology owner collects from other sources like the public sources. With that, he will use his intelligence and create some new things. Now, in the days of this artificial intelligence, a lot of things are created, and that is the reason why this person is willing to pick up this personal data, and from there he provides a marketable, let us say, a report or something like that, and that is a created data. Now, in terms of personal data, by legal definition, any data which can be identified to an individual, which is about the individual, about his health, about his finance, etc., they all become the part of the personal data. Now, suppose this particular company is a credit rating company. It has collected the name and address from this data principal, but it has collected information about his credit card activities, etc., buying activities, and then out of that, it has created a CIBIL rating kind of a thing. There is a lot of intellectual property input which has gone into this creation. And now the question is, who wants this created value? Now, unless a contract properly defines, there is a difficulty about segregating the value additions which happen because of technology into ownership of different people. In fact, technology creates value just by merging a couple of informations like aggregation, like filtering. So there are various ways by which technology adds or deletes value. And in the process, the output coming out of technology can be identified personal data, it can be pseudonymized personal data or anonymized data. What we mean by pseudonymized personal data is it is still personal data, but not clearly identifiable to the real data principal. So it is mixed up in some way. However, anonymized data means the data which does not have any identity of an individual. So normally anonymized data is considered as non-personal data. Now, when does this data becomes identified or anonymized? As I have indicated in the earlier slide, it all depends upon the human being who is sitting in this data fiduciary, who looked at NAAVI and said, oh, this person is an individual, I know him, kind of a thing. Similarly, when a doctor looks at an X-ray sheet, he gets some idea which I and you may not get. So the meaning of data is actually evident only when a human being sees it. Now, if that information is seen only by a machine and not by an individual, the question arises whether what the machine is reading is personal data or non-personal data. I will tell you why this is important. When AI looks at data, we say that, of course, we identify a software as artificial intelligence if it has the capacity to take decisions on its own. Now, every software works with specific instructions from a human being. We give a decision rule. If this is the input, this should be the output. So human intervention is there in almost all of the decisions of a software, and that is why Information Technology Act under Section 11 attributes any action of an automated device to the person who caused it to behave in such a manner. Therefore, all contractual obligations arising out of an automated processing, our Indian law attributes it to the person who is either the owner of that software or is the developer of that software. And in between them, they have to decide about the responsibility by the contract of sale or licensing of the software. So humans actually are involved in programming the software. But if I program a software saying that when you see something, you arrive at a particular output for which I have given you some directions, but then this output, you please add it as an additional experience in your machine learning process, and you can think of changing my original instructions. So suppose I give that power to the algorithm to recycle the output back as input and arrive at some new output, and that new output can override my personal instructions. Suppose I have said 2 plus 2 should be 4, and then out of several instructions I allow the software to say 2 plus 2 can be 5. Then the output which comes out of that as 5 is also because of the programming which I have done. But there is no human intervention at that point of time when the original code was modified. I only gave the permission to the software to modify the original codes, but when it actually modified, I did not have the human supervision of that. That is the real, say, AI issue, which you can call as a self-learning artificial intelligence. And in the case of AI, where it is dependent on the human code written, once it is being executed, there may be a library of database, from that information is taken and it does it. There is no legal issue because the software activity is completely associated with the owner of that software. So if it becomes a rogue and it does something wrong, then you have some owner to catch. Whereas in the case of a recycled information in a self-learning, machine learning mode, somewhere a problem will come in the court of law where the developer says, I did not know that this would be the output which would come. I did not specifically instruct the AI to come to this conclusion, but I was not aware that this could be one of the possibilities of that kind of a decision. Then the judge has to decide whether it is reasonable to expect that this developer should have foreseen this kind of a development and so on. There we come into a legal question, whether the AI algorithm, which is working as what we call as a super intelligence factor, self-learning, self-correcting mode, should it be considered as a juridical person? And we try to provide some kind of a legal issue about that. Just as today, if in a common law, minors, if they do certain things, their guardians or parents will be held responsible. For example, RTO must be having some rule like that. If a minor commits an accident, then the responsibility for that will be with the parent who gave the minor the authority to drive the vehicle. Likewise, in the case of AI, one way to look at it is like a minor. Therefore, whoever has programmed it, even in the intelligent, unsupervised learning method, should be held responsible. Or we put a break at some point of time that only if it is a supervised specific instruction based output, then it should be held the responsibility of the owner. Otherwise, you should say that this is the problem of technology. Nobody is responsible. It is an accident kind of a thing. These are the things which the law has to still decide, and that is the new challenge which we have in terms of artificial intelligence. Now, coming to this right of choice, Now, what if the right of choice itself is meaningless, which will happen in certain instances? For example, now, when a machine accesses personal data, there could be a process in which the machine can generate an output which is not identifiable. The input may be an identifiable personal data, processing is done, output is an anonymized anonymized data. In that scenario, should we consider that there is any privacy issue, or should we ignore? Is another challenge which technology is providing to us. Under the international GDPR kind of laws, even if data is accessed by an algorithm, a machine, irrespective of its intelligence, if it accesses personal data, then consent is essential. Now, it happens that in the case of CCTV footages, particularly in the streets, okay, personal data is being accessed by the CCTV. Most of the time, we do not know where is the permission for that. No permission would be there. So in such cases, one has to decide whether permission is required when the CCTV automatically captures the personal data of an individual, which can be a face or something like that. In case the CCTV footage is looked at by a human being back in the police control room who says so and so is walking across that, then the identification happens at the human level, not at the level of the CCTV. So therefore, CCTV does not infringe the privacy, but the person who actually interprets the CCTV image and connects it to a human being, privacy is required there. Therefore, permission is required for a back-end processor who is a human to identify the data which is flowing through. Suppose I create the algorithm in such a way that the machine does not release an identified picture to that back-end CCTV viewer, except, let us say, where there is some suspicion of a terrorist or something like that, then the CCTV does not infringe the privacy of an individual. I don't know whether I'm able to completely carry this view with you, because worldwide people are against CCTV being put up on the streets, but actually there is a technology related programming which can be done whereby CCTV may see a person. It may even analyze this CCTV footage with reference to known faces of, say, criminals and other things. And only where it identifies that a particular designated criminal is found in this CCTV, it escalates it into a human attention. In all other cases where I and you are going in the street and the CCTV footage accepts that, that may never go to the next human level. Therefore, we should not be having any concern about the CCTV footage. This is what is the difference between identifying data at the machine level as personal or non-personal, and at human level as personal or non-personal. Now, this is a definition of privacy which has to emerge, because we are increasingly finding technology coming in between the data collection and the data interpretation, and therefore there can be efficient use of technology without infringing the privacy. Now, in the case of a company or an organization, we have another issue where data comes in bits and pieces at different points of time. So maybe one division of the data collects the name, another division collects some other address, and in the server, it could be combined. So as a legal entity, the entire organization has got at a particular point of time both the name as well as the email address as well as, say, Aadhaar. Then the organization should consider that as personal information or sensitive personal information, though a single individual in that organization may not have all the information together. This is like, as we know in the banking industry, when a stop payment instruction is given to the manager of the bank, whereas the cashier, without the knowledge of the stop payment instruction, if he makes the payment, bank is still liable. Now, the inability of the bank manager to pass on that information to the cashier, or in some cases when it happens one branch to another branch, or extension counter, etc., that risk has to be borne by the bank. Similarly, in an organization where multiple divisions collect multiple informations which are personal information, when they are combined, the risk of infringement of privacy has to be borne by the organization as a whole. But you can ask me that how is it possible for a company which is having one office in Bangalore, another office in Hubli, some information is collected there, some information is collected here, and we are saying that both are there with the legal entity which is the same, and therefore it becomes personal data and it has to be protected. There has to be some compliance requirements. Now, this is the challenge which technology, particularly this distributed operations, internet, being able to connect people across the world at a split of a second, that poses a challenge to this concept of privacy. Therefore, when we build data protection laws, we may need a kind of exemptions where data, when viewed only by the machine, which is a software, AI, or whatever is that, but the output is devoid of identity, then should it be considered as personal data or not is a question which has to be raised. This is sometimes we call this as the definition of privacy as privacy 2.0 or something like that. So this is one of the challenges which we need to look at. Now, when you look at automated decision making, most of the privacy laws will say that automated decision making is what brings in the controls. Now, in the Indian law, which is being framed now, there is a definition of automated, which says automated means any digital process capable of operating automatically in response to the instructions given or otherwise. Now, if this or otherwise had not been there, we could have given such a manner that if the developer instructions, then that is what is meant by automated. Because of these words or otherwise, all AI algorithms become part of the DPDPB 2022, and the entire privacy instructions, including the compliance requirements, the rights, etc., they apply to artificial intelligence processed data. And an AI algorithm itself may become a data fiduciary, or the owner of that AI algorithm becomes a data fiduciary, and the algorithm itself becomes a data processor. Now, this is the reason why I say that in India, we already have a legislation for AI regulation. In fact, Information Technology Act also had a section 11, which attributed the automated functioning of a device to the person. So therefore, the ITA 2000, which has been in effect from 2000, and this DPDPB 2022, which is coming now, already have legislation for artificial intelligence, which is a future technology. So India is far ahead of the world in that kind of a situation.
Naavi, sir?
Yes.
Sir, sorry to disturb you. We have another speaker. So can you please wind up as early as possible?
Yeah, I will take another 5 minutes and wind it up. Okay.
Thank you so much.
Then the other challenges which are presented is the consent, which is an important aspect of data privacy, requires to be redefined with new types of consents like a discovery consent and maybe witnessed consent to be taken into account. Also, people talk about this re-identification of anonymized information. Our law considers this as an offense under Information Technology Act. Therefore, this proposed law takes into account the risk of new technology being used to defeat privacy. Now, apart from this, I would like to actually highlight that certain developments in neurotechnology where external brain-computer interfaces are being created makes this concept of right of choice completely meaningless, because an external person can change your right of choice in your mind. Therefore, we need to actually look at redefining the privacy from the mental privacy to neuro privacy and extend the rules which are applicable to information, which is binary data, to what we call as neuro data. And this has to happen as quickly as possible along with the AI related legislation. The world has moved around this and have identified certain neuro rights, and perhaps we will also be coming into that kind of a legislation shortly. Coming lastly to this metaverse. Again, metaverse is not much different from our current experience of the web, which is a two-dimensional thing, and metaverse uses a VR or a mixed reality device, which makes the experience different, and it becomes a sort of an immersive experience. And because it is immersive, the effect of metaverse interactions is much more on the brain of a person. It can be used for, say, cyber hypnotism, like we have heard about the blue whale game, which actually led people into suicide. That kind of adverse impact could be there in metaverse. And therefore, even though metaverse is not much different from the normal browsing, except the 2D, 3D, the avatar kind of a thing, there is a need for regulating the metaverse. Otherwise, we can say that metaverse is also something which is connected with data, and data is already covered under Information Technology Act. So every metaverse platform is like an intermediary, and we can apply ITA 2000 for this. And because it is possible to induce hallucinations through these VR devices, we say that this metaverse should not be neglected. It has to be reined in, just like this artificial intelligence, before it becomes too late. As far as smart contracts are concerned, the only one point I would like to make: smart contracts have the risk of being executed without the complete acceptance of the data of the people involved. It is like a contract where the meeting of minds does not happen. So therefore, it has to be taken into consideration when you execute a blockchain contract. You need to actually ensure that there is consent from the particular person. I think I will stop here. I will not go into the further details of the data protection bill. In case there is any specific questions, you can raise. Otherwise, we will close the discussion. Thank you.